Hi, everybody. Thanks for joining in to watch this webinar today, or if you end up watching it later in the future, great. Today, we're going to talk about commercial lease disputes. We are the Blake Law Firm. We're based in Encinitas, California, and we are a small law firm that handles a lot of real estate matters and a lot of things with commercial leases. And so we've had a lot of experience dealing with commercial lease disputes, and we hope that we can give you a summary of what is involved in commercial lease disputes. And again, I'm Stephen Blake. I'm the managing attorney here at the Blake Law Firm. And then also today, you'll hear from Andrew Hall, who is senior counsel at the Blake Law Firm. And our first slide here is an overview of the presentation. And what we're going to talk about today, first off, is what types of disputes happen with commercial leases. Secondly, what type of authority are we looking at when we're in a commercial lease dispute? What do the statutes say? What does the contract law say? And then we'll talk a little bit about dispute resolution with commercial leases, and then just tips to handling a commercial lease dispute. And then the last part will be about, in the event you do resolve a commercial lease dispute, how to finalize that resolution. So as to the types of disputes, Andrew, I think you were going to take this slide.
Yes, good afternoon, everyone. Thanks for tuning in. As Steve mentioned, my name is Andrew Hall. I'm a senior counsel at the Blake Law Firm. Part of my areas of practice include representation of commercial landlords in lease disputes. So we just wanted to share a little bit of our knowledge and experience with you all today, and kind of let you know what we're seeing out there, boots on the ground. So in terms of types of disputes, the primary type of disputes that we see come through the door are non-payment of rent is obviously up there, and probably the most common that we there's also a failure to maintain or repair the premises. Obviously, this is important for landlords to ensure that tenants aren't trashing the premises or committing waste. Evictions kind of relates to non-payment of rent, but if you have a tenant that's not paying, it's important to address that either through lease or through an eviction action to get that tenant out and a tenant into the property that will consistently make monthly rental payments. Obviously, over the last couple of years, given COVID, we're seeing a lot of COVID-related issues and questions. COVID kind of tied with a number of different areas, including evictions. Certain notices need to be given, and we'll get into that in a little more detail later on in the webinar. And lastly, we see quite a few AD disputes. That's American with Disabilities Act, properties that aren't in compliance, and landlords can be sued for out of compliant premises or property. Next slide, please. So laws applicable to commercial lease disputes. Obviously, general contract law drives these types of disputes. The four corners of the lease are very important, and anything in the lease will dictate action, obligation, and responsibilities going forward. So some examples of general contract provisions that we see in leases, obviously length of notice to pay or quit. Typically 3 days, but the lease could provide more time, days, even more, to remit defaulted payments. Type and location of service of notices is very important. If a tenant requires notices to go to a different address other than the premises, it's important that the landlord be aware of that and get notices to the proper address to ensure proper service. Base rent and CAM charges. So obviously having the CAM charges in there is important. It's more than just base rent, and tenants are responsible for not only base, but CAM charges as well. Special laws applicable to evictions. Evictions are an expedited process meant to be completed in a much quicker time than typical litigation. And those special laws now include additional notice requirements for COVID-related defaults. Lastly, there's a belief of abandonment, which can be a powerful tool for landlords if they believe a tenant has vacated the premises and hasn't made rent payments in 14 days. This allows a landlord with proper notice of the tenant to retake possession of the premises without going through the eviction process and spending a bunch of money getting a judgment and then a writ for possession, which time and money. So a leave of abandonment can be a powerful tool. Lease provisions applicable to commercial lease disputes. We kind of covered it on the last slide, but notification provisions are important. Mediation requirements, if a lease requires that the parties mediate before entering into litigation, it's important that both parties comply with that provision. Arbitration. Arbitration provisions allow either party to pursue recourse through an arbitration as opposed to a formal court proceeding. Force majeure provisions, we're seeing more and more litigation over these as it relates to COVID-related issues and non-payments. And then lastly, attorney's fees. Leases with attorney's fees obviously allow a prevailing party to recover attorney's fees in the event that litigation ensues and a party prevails. So it's important for landlords to recognize those in there, and it often helps negotiation as well.
So the dispute resolution process involving commercial leases, going into a little bit more detail than what we were talking about before, is typically involves a notification process and a cure period before the default has been formalized, so to speak. And typically when there's a dispute under the lease, for example, non-payment of rent, you're going to look at the statute to see what it says about the tenant's obligation to pay rent, but you're also going to look at the lease. And Andrew touched on this earlier. Sometimes it's going to say that in order for the tenant to be in default, they have to receive notice of the default, and the lease and the statute is going to provide a specific way to give that notice. And some of the important statutes are this Code of Civil Procedure, section 1161.1, and this involves the commercial lease context where the dollar amount that is in your notice to the tenant can be an estimated amount. So for example, if there's a water leak at the premises and it's the tenant's fault that the reason this water leak happened, and the landlord repairs it, and let's say they spend $100,000 repairing it, and then they're making a demand on the tenant to pay it, they can send out that notice, and it could be an estimated amount. So like, even though the amount could be in dispute, it's still proper notice. And then secondly, this statute, Code of Civil Procedure, section 1162, it requires that the notice be served in a certain way. And it's important that the landlord follows these rules to make sure that the notice isn't deemed void later, because that's not a good place to be if you end up in litigation and then, down the road a year, you find out that the notice isn't valid. So it's important that the landlord checks the code and also checks the lease before serving any of these notices. And then an issue that often comes up in the notification process is you notice the tenant of the amount that's owed, and the tenant makes a partial payment. And let's say, that's $100,000 that's owed and the tenant pays $30,000. What are the consequences of the landlord accepting that money or rejecting it? And it's important to understand that, because sometimes an acceptance of the money could be a waiver of the notice, and you'd have to serve a new notice and give the tenant a new opportunity to cure. So it's important to understand those rules. And then calculating the cure dates. So this is important as well, because when you serve a notice to cure, such as like a 5-day notice to pay rent or quit, you're giving that tenant 5 days to cure. How do you count those 5 days? And typically what happens is you count the following day after service as day 1, and then count your days. And if it falls on a holiday or a weekend, you roll it over to the next business day. But it's important to understand that there's nuances as to how you calculate the days. So don't just think it's 5 days and it's done. If the tenant, pays on the 6th day, that may actually be the 5th day, depending on how it's calculated. So make sure you understand that as well. We talked a little bit about this earlier, the dispute resolution process, mediation and arbitration. Mediation, a lot of commercial lease agreements that you'll see are going to include a mediation provision that says that the parties agree to mediate any dispute before they resort to legal proceedings. And mediation, if you don't know, it's a private process outside of court that's voluntary between the parties. And there's a person that's acting as a mediator, which is usually an attorney or a retired judge. And their role is to try to negotiate a resolution between the parties. They're not making any orders. It's not like a court hearing where you're presenting evidence to a neutral and then they make a decision. The mediator's role is to just try to negotiate a resolution. If the parties are unable to come to a resolution, then the mediation's over and the parties have completed that precondition in order to file litigation. Arbitration, if you don't know, that is different than mediation in the sense that it's a binding process where the arbitrator is a neutral that's selected by the parties, but it's similar to a court proceeding where you are presenting evidence to the arbitrator and the arbitrator will make a decision and that decision is binding on the parties. So it's not voluntary where they come to an agreement like a mediation. Arbitration is similar to court. It's just takes place outside of court. And there's a bunch of different companies that offer arbitration services. You typically arbitrate with a retired judge. They charge an hourly fee. So it can be expensive. And that's one thing to consider. A lot of people have arbitration clauses in their lease agreements, but they really don't understand what an arbitration is or how expensive it can be. So that's something you can deal with on the front end when you're signing the lease. But at the end of the day, if there's a dispute and it requires arbitration, you're obligated to arbitrate it unless the parties waive that arbitration. And then lastly, in a dispute resolution process, one thing that's extremely important is contact with the tenant and just understanding what the tenant's objective is, because there could be a non-payment of rent situation and you're thinking litigation or arbitration, whereas the tenant may want to assign the lease. Maybe their business has experienced difficulties or they're willing to negotiate a resolution. So make sure that before going into litigation, mediation, arbitration, that there is contact with the tenant. And if there's a way to work a deal with the tenant outside of court, great, that should be explored. And then the final thing regarding dispute resolution process is going to court. And again, this is if all else fails and there's really no other option, a landlord or a tenant is entitled to file a lawsuit in court. And typically the types of complaints you see in a commercial lease dispute are a breach of lease, where either the landlord's accusing the tenant of breaching the lease for some reason, such as non-payment of rent, or the tenant is accusing the landlord of breaching the lease for some reason. Could be they're not providing services to the premises that they're required to provide under the lease. But there's a whole bunch of different things. But you would file the complaint in court. If it's a money issue, one of the options is to file for a writ of attachment. And this is a procedure that can be used by a landlord when they have a defaulting tenant with the payment of rent, and that amount of rent is certain. You can ask the court to attach assets of the debtor or the judgment creditor, or the judgment debtor, I'm sorry, who would be the tenant in this case. And the tenant would be required to, the court would attach those assets pending the trial. So if the tenant owed $100,000 of rent and you can file for an attachment writ, the court can give you that, and it essentially, freezes the tenant's assets in that amount until trial. This can be used as a very strong negotiating tool if you do this early on in the case. So you don't have to wait until trial to do something like this. But again, it's a complicated process. I'm just really scratching the surface of it. Discovery, this is important if you're in litigation on a commercial lease dispute, because at the end of the day, if the landlord gets a judgment against the tenant, it's only good if it gets paid. And in order to get paid, the tenant has to have money to pay it. So one of the things to discover in the case is what is the tenant's financial situation. And that's going to be important to how you decide to move forward with the dispute resolution process. And then another procedure that's available in court is a motion for summary judgment or adjudication. And this is important, especially in today's world of the courts, because the courts are taking a really long time to set cases for trial. In some cases, it's 18 months to 2 years. And you don't really want to have to wait that long to get your dispute decided. So you can file a motion for summary judgment. And again, this is a very technical procedure in court. There's a lot of rules involved, but essentially you're asking for a judgment short of trial. So you're depriving the other side of their day in court, but you're arguing to the court that nothing's in dispute. The court can issue a judgment. So sometimes in like a non-payment of rent case, this is relatively straightforward motion because, the lease is what it is. The amount of money sometimes isn't in dispute. It just hasn't been paid. So the court can handle those type of motions relatively easily. Andrew, do you want to jump on this one?
Sure. So handling a commercial lease dispute, a few things to do up front. Obviously, the lease is important. Related documents could be amendments to the lease or assignments to the lease. It's important to go through each one carefully to really suss out what the landlord's rights and obligations are under those governing documents. Again, lease disputes are heavily contractual, so the documents are very important there. You want to understand the objective of the parties, and kind of along with that is understand the financial means of the tenant and the market in which the property is situated. So, for example, if you're a landlord with a tenant that's making partial payments, you want to consider whether you have another potential tenant waiting in the wings, or whether the market's a little dry and you need someone in the building paying before determining whether to move forward with an eviction. Sometimes receiving those partial payments and working with the tenant can be more beneficial than running into court, getting a judgment, getting that tenant out of the unit, and then spending months trying to find someone to step back in. So it's very important that the landlord, you work with your brokers, understand what the market is for that particular property. And then objective of the parties. Objective of the parties. As a landlord, obviously you want to recover any past due rent, but again, you also want to work with your tenants to make sure that you have someone in there that's paying. And sometimes partial payments better than giving nothing at all. All right. COVID-related considerations. These relate to notices. If a landlord wants to evict a tenant that's making no payments, I won't go through it. It's kind of a complicated process, but just a couple key things to know. One being the protected time period versus the transition time period is important. So you'll want to determine whether the rent paid was paid during that protected time period between March 1st, 2020 and August 31st, 2020, or whether it was paid during the transition time period from September 1st, 2020 through September 30th, 2021. And the significance of this is that there's 15 days to pay or quit versus whatever's in the lease, whether it be 3, 5, 10 days. So the tenant would have 15 days to pay or quit. The notes contain the amount demanded and the date it became due. This must advise the tenant that the tenant not evicted for failure to comply if a signed declaration of COVID-19 financial distress is provided before the expiration of the notice. So a couple of things there. One, you want to make sure that the signed declaration, that it is a signed declaration made under the penalty of perjury, but two, that it's provided before the expiration of the notice. If it's provided after, then the landlord might be able to get out from under some of these COVID restrictions. And lastly, it must contain statutory warning, some verbiage that the legislature has laid out that must be included in the notice. When a tenant does timely deliver a COVID-19 related financial distress declaration, the tenant's deemed not in default during the protected time period. And this is where it becomes essential to determine the various time periods that apply, because for the transition time period, In addition to providing the declaration, the tenant must pay at least 25% of the rent demanded in the notice. So the protected time period declaration, here it is. I don't have to pay anything. This is a time period. Here's my declaration and my 25% of rent. And if those are done, then the landlord can't move forward with an eviction. Now, what's key to understand here is the difference between an eviction action and a breach of lease. The eviction is used to recoup possession of the premises, whereas a breach of lease can be used to pursue the tenant for non-payment of rent. And what we're seeing is more of the latter than the former lately, given these restrictions. And the filing of a breach of lease action against a tenant can be a powerful tool to negotiate, whether that be for payment of the balance of the rent, or perhaps renegotiating the lease to keep that in and keep them paying.
Yeah, and I would just add to that when looking at like the COVID related considerations, it's really important where the property is, because what we've seen over the last few years with COVID is that you're going to have eviction and commercial lease related regulations and emergency orders at the state level, the county level, the municipality level. So it's important to check all those, because it honestly, depending on the community you're in, the rules can be different. And some communities are very restrictive, some are less restrictive. There's state regulations on top of everything. So it's a area when you're looking at these COVID restrictions on evicting tenants and terminating leases, it's important to understand all the different layers of regulations, because there's a lot and it's constantly changing. So that's something that it's important to look at that before serving a default notice.
And then lastly, I just wanted to touch briefly on finalizing a resolution. Hopefully you as a landlord, you as a tenant can work with each other to resolve your dispute. And in doing so, it's important that the final resolution be documented, whether that be in a settlement agreement. So if a court action is pending, then it's important for the parties to enter in a settlement agreement. There are some key provisions that you'll want to include in there. It's important to consult with your attorney about what needs to be in that settlement agreement. But it should definitely be in writing. Obviously, handshake is reliable for a type of resolution. So a settlement agreement is important. Potentially an amendment to the lease. So again, if a landlord and tenant work out, an amendment to the lease, that obviously needs to be in writing. If a court action is pending, then a stipulated judgment, especially from a landlord standpoint, is a good tool. It allows, for example, resolutions where a landlord and tenant enter into an installment payment agreement over several months. And the stipulated judgment is important because if the tenant were to breach that agreement, then rather than the landlord having to go back into court and retry the case, they have a stipulated judgment that they can enforce immediately. So that's definitely a solid tool for a landlord to keep in mind in a litigation. And again, just to reiterate, any type of resolution should always be in writing.
And if the settlement involves terminating the lease, some of the things that are important to consider too is, when is the tenant going to be gone? What personal property is going to be removed by the tenant? What personal property is going to stay? What do you deem a fixture? What do you not deem a fixture? It's important to address all those issues so that when the tenant leaves, that there's no issue about what was taken or what should have been left behind. Because oftentimes we've seen commercial landlords and tenants have very different views of what is a fixture and what's not a fixture, and what is attached to the property and what can go with them at the end of the day. So thank you everybody for watching. I don't know if any of the viewers have any questions right now. I know that Daniel's on the line. Do you have any questions, Daniel?
No, I'm good. Good job, guys.
Hey, thanks a lot, Daniel. Well, hey, a lot of this stuff is really complicated, And we were just trying to give a brief overview of the process and some of the key issues that pop up in commercial lease disputes. But as you can see, there's a lot of questions and there's a lot of technical requirements that need to be met when handling these types of disputes. So if you do have any questions, please let us know. Our email addresses are on this slide, and you can email us at any time. So from me, thank you very much. And Andrew.
Yeah, thanks for tuning in, and we look forward to hearing from you.
All right. Well, thanks, everybody. Have a great day.
You too. Bye.
Take care.